Welcome to this explainer. I am absolutely thrilled you're tuning in today because we're tackling something that is just incredibly fundamental. We are diving deep into the foundations of civil justice. Specifically, we're going to explore how abstract legal rights, the concepts you read about in textbooks, are actually transformed into real-world justice in Pakistan. It is a fascinating journey from theory straight into practice. So, let's jump right into it.
So ask yourself, what good is a legal right if you literally cannot enforce it? Imagine you finally own a piece of property, or maybe you've just signed this massive commercial contract. Now, those documents absolutely grant you substantive rights, but if someone trespasses on your land or entirely breaches that contract and you have absolutely no mechanism to force them to make it right, well, those rights are pretty much just empty promises, aren't they? They're basically invisible ink on paper. You absolutely need a reliable, predictable system to actually enforce those rights in the real world.
And that brings us to a really powerful way to look at the Code of Civil Procedure of 1908. It's often described as the procedural machinery for the administration of civil justice. Now, I know a lot of law students and young practitioners see the CPC as this incredibly intimidating and penetrable rulebook. But honestly, I want you to look at it a bit differently today. Think of the CPC as an essential stabilizing blueprint. It's the architectural plan specifically designed to take the absolute chaos of unresolved human disputes and organize it into a fair, orderly process. All right, here is our roadmap for this explainer. First, we'll cover the machinery of justice. Then, rights versus procedures, the court hierarchy, the three pillars of jurisdiction, the doctrine of finality, and finally, procedure as a safeguard. Section 1. The machinery of justice, the CPC objectives. Okay, let's actually unpack this and see how the CPC operates as the absolute bedrock of the whole system. The framers essentially built this blueprint around four interlocking objectives. First up, uniformity. You see, before codification, procedures were just all over the place. The CPC creates one single, highly predictable standard. Second is fairness. It bakes natural justice, meaning the right to notice and the right to actually be heard, into every single step of the process. Third is efficiency. It specifically channels litigation into fixed, orderly stages, things like plaints, written statements, and evidence, mostly to prevent unnecessary delays. And fourth, finality. The system absolutely has to guarantee that disputes actually come to a permanent end. So together, these four objectives completely replace arbitrary, random decisions with systematic, predictable conduct.
Section 2. Rights versus procedures, substantive versus procedural.
Let's make a really important distinction here. Think about the difference between the physical materials used to build a house and the actual blueprint used to assemble it. On one side, you have substantive law. This would be things like the Contract Act or the Transfer of Property Act. These laws create your rights and your liabilities. They are the bricks and mortar. On the flip side, you have procedural law, primarily the CPC. Procedural law dictates exactly how you enforce those substantive rights in front of a tribunal. So the key takeaway here is this. If you suffer a breach of contract, all the substantive rights in the world aren't going to save you if you don't know the procedural mechanics to properly file and try your suit. The building materials completely rely on the blueprint.
Section 3. The court hierarchy, structure of civil courts.
All right, so we understand the blueprint. Now, where do we actually put it to use? Let's look at the physical architecture of Pakistan's civil courts, kind of structuring this from the top down. Right at the apex, the very top, we have the Supreme Court of Pakistan, which is the final appellate authority. Just below that, we have the 5 high courts, and they exercise superintendence and appellate jurisdiction over their respective provinces. Then we drop down to the district level. This is where the district judge and additional district judges supervise and hear appeals. And finally, the foundational tier, the civil judges classes 1 through 3. This right here is where original jurisdiction happens. It's where suits are initially filed based on their pecuniary or, monetary limits. Visualizing this hierarchy really helps you see exactly how a single case can travel from the ground floor all the way up to the apex.
But hold on a second. Our House of Justice actually has some very specialized rooms. Running right alongside the general civil courts, there are specialized tribunals. We're talking banking courts, family courts, rent tribunals, consumer courts, environment tribunals. These forums are designed to apply very specific special statutes. So if you're dealing with a family dispute or maybe a banking recovery issue, these specialized tribunals have exclusive jurisdiction. That means the general civil courts are entirely ousted from the process. You literally have to make sure you walk into the right room.
Section 4. 3 pillars of jurisdiction. Authority to hear cases. Think of jurisdiction as the absolute foundational property lines that dictate exactly where your legal case must be constructed. And please, notice the severity of this rule. Jurisdiction is quite literally the legal authority of a court to hear and decide a case. If a court hears a case without actually having the proper jurisdiction, well, the resulting judgment is a complete nullity. It has absolutely zero legal effect. And here is the kicker. You cannot just magically fix a lack of jurisdiction by having both parties consent to it. It doesn't work that way. Filing in the wrong forum is a fatal error right out of the gate.
So keeping that in mind, under Section 9 of the CPC, a civil court's authority is limited by 3 core pillars. And here's the thing, all 3 have to be satisfied simultaneously. Number 1, territorial jurisdiction. Is the court geographically competent? Usually you file where the defendant resides or where the cause of action actually arose. Number 2, pecuniary jurisdiction. Does the exact monetary value of your suit fit within that specific court's financial limits? And number 3, subject matter jurisdiction. Does the court even have the authority to hear this specific type of dispute, or is it barred because it belongs in one of those specialized tribunals we just talked about? You have to hit all 3 to build a valid case. And once you've successfully built it, and the court rules, we need a really sturdy roof to lock the whole civil justice structure in place. Section 5. The doctrine of finality. Ending litigation. Okay, let's talk about a Latin phrase you're going to hear a lot, res judica. It translates pretty simply to a matter judged. Found in Section 11 of the CPC, this doctrine legally bars you from relitigating a matter that was already directly and substantially in issue in a previous suit between the exact same parties and decided by a competent court. Basically, it completely protects everyday citizens from being dragged into endless, exhausting, repeating lawsuits over the exact same issue. I absolutely love the translation of the underlying legal maxim here. It is in the public interest that litigation should have an end. Think about it. A functional justice system simply cannot allow the losing party to just keep rolling the dice in different courts over and over until they finally get the answer they want. There absolutely must be a definitive, rock-solid endpoint, both for the sake of public confidence and to preserve judicial resources. Now, here is a massive, and I mean massive, procedural trap. It's called constructive res judicata. The law states that any claim or defense that you could have, and frankly should have, raised in your very first suit, but didn't, well, it's legally deemed to have been dealt with anyway. You cannot just save a backup argument for a rainy day in a second lawsuit. No way. What this means in practice is that before you ever file a suit, you must conduct a highly rigorous, comprehensive cause of action audit. You have got to bring every single claim, every defense, and every relevant party to the table the very first time. If you don't, you lose them forever. Section 6, Procedure as a Safeguard, Constitutional Framework. So, let's connect all these mechanical blueprints right back to you and your personal rights. It's really easy to look at things like jurisdiction and court fees and res judicata as just, annoying bureaucratic hurdles. But they really aren't. They're the actual physical manifestation of Article 10A of the Constitution of Pakistan, your fundamental right to a fair trial. The specific rules regarding how a summons is served, they ensure you aren't judged in the dark without notice. The rules of evidence, they make sure judgments are based on cold, hard facts, not just rumors. Procedural law is essentially the real-world shield that guarantees your constitutional right to fairness and due process is actually respected. I want to leave you today with a pretty provocative thought. The civil courts in Pakistan handle hundreds of thousands of cases, and unfortunately, so many of them get completely derailed not on the actual facts of the dispute, but on totally avoidable procedural missteps. So if justice delayed or denied really starts with a misunderstanding of these very foundations we've covered today, how will you build your next case? Having a truly deep understanding of the Code of Civil Procedure completely empowers you to navigate this vast system strategically, efficiently, and fairly. I really hope this explainer has energized you to look at procedural law not as some heavy burden, but as your absolute greatest tool. Thanks so much for joining me, and keep learning.